Good morning. It is December 7th, and we're meeting for the Environmental Control Board's December meeting. I'd like to call the meeting to order as chair. We will first review the agenda and make some adjustments. Item number 2 on the agenda is welcoming new board Lisa Urban. I'm going to move that down after the executive session. And otherwise, why don't we start with a roll call to verify quorum? If the GC's team would please take the lead.
Good morning, all. We'll start with Commissioner Asim Rahman,
Present.
Chavanda Graham, Joseph Gregory,
Present.
Elizabeth Nauer,
Present.
Madeline Ligori,
Present.
Arminda Parvana,
Present.
Russell Pickens,
Present.
Matthew Snide,
Present.
Thomas Pender,
Present.
Matthew Smith, Douglas Swan, Gerald Whittington,
Present.
Lisa Urban. We have a quorum 8 out of 13.
Okay, thank you very much. Next order of business on the agenda are the minutes from the October 12th, 2023 meeting. I hope everyone has had a chance to review. Does anyone have any corrections to the minutes? Okay, hearing none, seeing none. Can we have a motion and a second to adopt the minutes of the October 12th, 2023 meeting?
Motion.
Let's see, a motion from
Second.
Madeline, a second from Matthew Schneid. Any objections? Please take a vote.
Are there any objections to the motion approving the minutes of the October 12th, 2023 EC meeting? Seeing none, hearing none, the motion is approved unanimously.
Okay, thank you. We'll now move to the Department of Environmental Protection's request for cease and desist orders, and I'll turn it over to Russell Pukunis.
All right, thank you. Russell Picuni is with DEP Legal. So for this meeting, DEP's Bureau of Wastewater Treatment is asking the board to issue 2 cease and desist orders. The first one is for the Boston Market at 3371 East Tremont Avenue in the Bronx. DEP inspected this premises, and on June 7th of 2022 issued a commissioner's order to the restaurant requiring them to install and maintain several grease interceptors. Because they failed to comply with that order, DEP then proceeded to issue several summonses for section 24-524F for failing to comply with the commissioner's order. During the issuance of those summonses, while they were being issued, actually at the issuance of the next to last one, I think, the DEP inspector observed one of the respondent's employees dumping a 5-gallon bucket of grease into a catch basin. And so at the end of the issuance of all of these summonses, the most recent one having been issued in July, and since the respondent has failed to appear for the hearings and also failed to appear for a compliance meeting that they were ordered to attend in June, and since there is still no compliance with the order to date, DEP is asking the board to issue an order to cease and desist.
Are there
Do we want to do this one separately?
We'll do it one by one.
Okay.
Thank you, Russell. And does anyone have any questions, Russell? Go ahead, Pat.
So there's just been no response whatsoever to any of the violations, any of the meeting requests?
Appear to be in default as to the violations, although if you look at the printouts, they did pay the default penalty on one of them. But the rest of the summonses are in default, except I think the most recent one, it might be still pending hearing date, but the rest of the rest of them are all in default and all unpaid except for one. That they do seem to have paid the penalty on.
Well, if they managed to pay one, I gather they received the information. Okay.
Hmm?
If they paid one, I gather they received the information.
I mean, if they paid on one of them, I'm assuming that they did, that their non-responsiveness is not because they don't know about this.
Right.
But I had a similar reaction of reading this, Russ. And could you explain to us for the order that's issued after the summonses go out, the commissioner's order, how is that order delivered? Is it mailed? Is it brought over and turned over to an employee?
So let's get to the order. Yes, yeah. Okay. Yeah. So the order is, would be served by inspector.
Okay.
And the inspector's telephone number to call is at the bottom. And then they would also put a copy, in the mail.
Okay, so in the inspector service would be an in-person service?
They would go to the restaurant and give it to whoever was there.
Okay,
And then they would also put a copy in the mail.
thank you. Any other questions for Russell on this one? Okay, I'd like to request a motion and a second regarding the request for cease and desist order relating to the Boston Market Corporation.
Motion.
Okay, motion from Harminder Paul and a second from Joseph. The vote.
Are there any objections to approving the cease and desist order? Seeing none, hearing none, the motion is approved unanimously.
Okay, thank you very much.
Thank you.
You can proceed to the second.
Yeah, and the second one pertains to the Van Leeuwen Ice Cream at 5456 Dobbin Street in Brooklyn. For this one, the inspection determined that they needed to install a grease interceptor for several fixtures. This is an ice cream store, but the grease interceptors are not just for cooking. It's for fats, oils, and grease. So since ice cream does involve milk and fat, the grease interceptor is required for this facility. So they were issued a commissioner's order in September of 2021. Due to non-compliance, a series of summonses were then issued up through May of this year. And there is still no compliance. They have paid three of the summonses, and rescheduled one of them for some reason, which is rescheduled to January. But because of the continuing failure to comply with the order, DEP is also requesting a cease and desist order be issued on this one.
Thank you. Any questions for Russ?
I do. I guess I have a question about, they rescheduled the last summons until January. Do you think their expectations are that they'll sort of have an opportunity to present their defense if they have one?
I don't know why they would have paid three of them, including two of them, one of them where they paid the default penalty, and then rescheduled this one. I don't know the answer to that because we don't know why people reschedule. It just shows up on Ticket Finder that it's rescheduled. So
But are they, I'm sorry to interrupt, are they required to appear at a hearing for this violation, or they could have just paid?
it just, I'm not sure. All we can tell is whether they paid it or what the current status of it is on Ticket Finder.
But Elizabeth, are you asking that if they decide tomorrow that they want to pay, they could pay and avoid the hearing? Is that your question?
Right, right. I'm just asking, is this the type, I think there are some violations that require you to appear at a hearing or require the respondent to appear at a hearing, and others you. They can.
I don't think these are, I think these can be admitted without an appearance. I'm just looking at the summons to see. Yeah, I think these can be admitted without showing up at the hearing.
Okay, so there's,
Because on one of these, two of them, it just says paid in full. One of them, it says defaulted and paid in full. So,
so the fact that they rescheduled the hearing suggests that they have some defense that they want to.
I couldn't address that. I don't know why they rescheduled it. Maybe there's a new manager at the store who is now going to pay attention to this. We wouldn't know until January when the new hearing date comes up.
So I'm,
We know that as of now, they still have not complied with the order that was issued over 2 years ago.
There's an added feature here, which is, and I, please would request correction if I'm wrong on this, that if it goes to a hearing and the only relief that can come from the hearing officer is the penalty. The hearing officer can't direct complaints. And so if the concern is, well, they have a hearing coming up, maybe we should wait for the hearing. The outcomes are either going to be that it's going to be dismissed or that it'll be upheld, and if it's upheld, it'll be a penalty. Whereas what DEP is seeking here today is not just the financial penalty, it's the opportunity to stop the business.
Right, but 3 of them have already been upheld because they've paid 3 of them.
Right, I was raising it more because, Elizabeth, if what you're thinking is, well, we let them go to hearing, they've got a hearing coming up, why don't we wait? I'm thinking the same thought myself. That doesn't necessarily mean that then the same relief that's being sought today would come out of that hearing. The most that could come out of that is the penalty, not necessarily the change in behavior.
yeah, I understand that. I guess I'm just, I guess my thought process was, given that, it's gone this long and now they do have a hearing scheduled. Would it make sense to allow them to proceed with that hearing to determine whether the violation will be dismissed or upheld? And then if it is indeed upheld and they don't present any substantive defense, or they don't present, or if it's dismissed for other reasons, like a service issue, then perhaps putting this off until the next, one more month. I guess we're only meeting quarterly, so it'd be longer, but.
Well, technically, what we might discuss at the end of today's meeting would be the next meeting for February. So if the hearing date is January 25th, and there's a decent chance that maybe not by February 1st, but by February 8th, a judicial hearing officer would have rendered a decision. And that could still be appealed, but at least we'll know the status of that hearing.
I have just one thing to think about. Even if the ticket is dismissed at the next hearing, that doesn't erase the findings of guilt or admission from the previous 3 summonses. So basically, he's admitted and conceded that, there's an issue to be fixed here. So even in the face of a dismissal, the correction wouldn't affect the correction.
Well,
Previous 3 summonses. Because I don't anticipate that at the hearing officer is going to say, look at this ticket. this was issued with absolutely, they're gonna find maybe it's probably not properly filled out or something, or not properly served. It's not gonna be a substantive thing of this did not happen. So we have a situation where the thing happened and there is the equitable remedy, and right now EPC speaking, but the equitable remedy. And that this is the only forum for the equitable remedy. The legal remedy can happen or not happen at the hearing. So it's kind of, I see what you're saying. Like if we were just talking about guilt or innocence, the propriety, the ticket, et cetera, I would say absolutely, let's just give the guy another chance to show up and do his thing. But we're talking about the equitable remedy here. So that not to try to change your mind, just for you to consider that, because I don't know if they're really analogous. I don't know if they're really.
Well, I understand the difference in the remedies, but I think there's like a theoretical possibility at least that they could come to the hearing and provide some substantive defense to the predicate. That even though like that wouldn't erase their liability for the past violations, it may indicate that there isn't a need for a cease and desist order based on facts that are now present, like they're like the store is closed or they're only selling packaged items or something like that. I'm just saying that that's a theoretical possibility that I guess they could bring that same, defense to a cease and desist hearing, but it's just, I don't remember a situation where we had like a hearing that was pending and in the midst of that issued a cease and desist order.
Well, on the normal ones that we submit for violations for air or noise, we usually only bring them to the board if there's been at least three issued.
Mhm.
And at least one of them is usually pending.
Oh, okay.
And we have at least two violations, but there can still be one. There
Okay.
usually is one pending at the time that we ask for the cease and desist order. For air and noise, it's usually two adjudicated, and then we issue a third one, and that's when we come to the board, because at that point, there's a pattern that they're not coming into compliance.
Okay. Well, thanks for correcting my memory there. So I will remove that objection then if this is standard for posture.
It's also just notable that there was a summons from October 2022, not for a condition violation, but just a failure to comply with the order. So there's an order, and now this is all about failure to comply. And that is the one that's going to hearing. But then there was a subsequent summons in May of 2023 that they paid on. So it's the prior summons that they're saying we want a hearing on, and then a later summons they paid on. And so it would be.
So it seems likely that that's a service issue or something like that.
Because if it's a failure to comply with the order, the substantive defense may be, no, we complied with the order. Look, we're doing all these things, but then why would you pay in full on the subsequent?
Yeah.
The summons that came later.
Yeah, and we don't know, because this is a chain, and there's probably a corporate office, and someone in that office is making decisions on how to deal with these, and maybe somebody decided to just send a check on some of them, and maybe somebody got a hold of this one particular one and decided to reschedule it.
And then
you have no idea.
I'm sorry, Matthew, were you going to say something?
No, I'm taking it all in.
Okay, so from a process standpoint, the cease and desist order, if issued, would be a cease and desist with an opportunity for a hearing.
Right, they then would have a hearing scheduled to show that they've come into compliance.
Right, and what are the turnaround times right now between cease and desist order and the hearings?
At least from the time the board approves it, I would say till the hearing date is scheduled, probably at least 6-8 weeks.
Okay. All right, other questions? Is there any opposition as a general matter for discussion purposes? We're going to take a vote, but from a discussion standpoint. Okay. All right, I'd like a motion to vote on the request for a cease and desist order relating to Van Leeuwen Ice Cream LLC. Okay, motion from Madeline, second from Jared.
Are there any objections to approving the cease and desist order? Seeing none, hearing none, the motion is approved unanimously.
Thank you. Thank you very much.
Thank you.
Before we move into executive session, I just want to take note that we've been joined by our newest board member, Lisa Urban. We'll have an opportunity after executive session to introduce Lisa more formally, but we'll now move into executive session. Okay, thank you. We're returning to public session for our December 7th ECB meeting. I'd now like to move to what was previously number 2 in the agenda, welcoming our newest board member, Lisa Urban. For those of you who haven't had a chance to meet Lisa, Lisa is a partner at Mavrides, Moyle, Packman, Sadkin LP, and she has many, many years of experience specializing in commercial and residential real estate. Lisa received her bachelor's degree from Stony Brook and her JD from Fordham Law School, go Rams. And so welcome, Lisa, and we look forward to working with you and look forward to your contributions on this board.
I apologize for being late. Thank you.
No.
It was a tough morning.
No problem at all.
Usually I'm not late. but-
If you'd like to say anything to introduce yourself, you're
Um,
welcome to.
Just, I'm very excited to meet everyone, to be a part of this. It's something, I've been looking for something to add to my sphere of work and interest, and being a resident. I've lived in Manhattan for a long time and been a city resident for a long time, and I'm excited to contribute and be a part of this board. So I'd look forward to working with all of you.
Great. Well, all of us are at your disposal in the interim. If you have any questions just about the experience of working on the board, feel free to reach out to the folks here, particularly the appointed members who
Okay.
will be able to share their experiences with you as well. Okay, we are going to next move to the selection of dates for our next board meeting. David, please.
Possible dates we have are February 1st, 2024 and February 8th, 2024.
You said February 3rd.
One
First,
and eight.
first,
Yeah.
first and eighth.
Does anyone have any concerns or objections to either of those dates? Okay. Shall we do February 1st? Okay.
Sure.
We'll sit down February 1st, 2024 as our next date. And before we adjourn, let me just take a moment to note that this is our last meeting of the 2023 calendar year. And it has been a very, very busy year for the board. By the end of the calendar year, you all will have reviewed over 2,000 appeals decisions through the panel process. And on top of just those numbers, we've spent this past year having some fairly in-depth discussions on some challenging topics that have been very much as part of the public discussion. And when we have those discussions, you've all brought a high degree of professionalism and thoughtfulness and respectful discourse to the table, which is much appreciated. This is also a year where some of the topics we looked at were very much topics that were in the public eye, whether it being discussed in the press, whether it being discussed at city council. And that public discussion, did not distract any of you from doing the important work of the board, the important work that the government of New York City and the members of the public rely on us to do. This was also a year of transition in several ways. We have just welcomed a new board member. We welcomed Parminder Pal as our new DOH-MH representative this past calendar year. We also transitioned from the virtual space back to the in-person space, among other things. And so let me just say, with all of that change, with all those challenges, again, as chair, how much I appreciate the time, effort, skills, expertise, and professionalism that you all bring to this work. It helps us meet our mission, and it's very important to the city. And with that, let me say that, for any of you who are celebrating holidays or have winter vacations, I wish you a safe time, and I wish you all a very happy new year, and we'll see each other in February. With that, motion to adjourn the meeting. A motion from Elizabeth, a second from Matthew. Okay, we are adjourned. Thank you very much, everyone.
Sign the signing. Yeah, just.